housing is vital to Arizona and its continued economic growth. Employers need housing choices for their employees, and rental housing offers the greatest convenience, flexibility, and relative affordability than any other option. Nearly 1/3 of Arizonans rent their homes, and while 40% of renters can afford to buy a house, they choose to rent instead. Over 21,000 Arizonans make their living directly from the rental housing industry, which is the 6th largest industry in the state.
The Arizona Multihousing Association provides its members with networking, advocacy, and training services. In 2006, 6,466 industry professionals attended AMA training programs. In addition, AMA members are actively involved in the communities in which they live and operate. This year, over 3,500 Arizonans received family safety training from the AMA, and our members raised just over $105,000 for the transitional housing shelters UMOM New Day Center in Phoenix and New Beginnings for Women and Children in Tucson. This video briefly describes legislation the AMA is supporting in 2007. More information can be had by contacting the AMA or our lobbyist.
The Residential Landlord and Tenant Act states that a rental agreement may contain terms and conditions not otherwise prohibited by law. Nonetheless, there are some common lease terms that, while not prohibited by Arizona law, have resulted in frivolous lawsuits in other states. The AMA is seeking to remove ambiguity and affirm what is already common industry practice. Inexpensive renters insurance is widely available, but each year hundreds of renters lose everything because they fail to buy coverage. Landlords are left to absorb millions of dollars of tenant-caused property damage. Just as mortgage lenders require people to purchase insurance to protect the lender's collateral, some landlords now require residents to purchase renter's insurance. It's a practice that makes sense for everyone. Many leases contain a provision to allow tenants who wish to move before their lease expires to pay a predetermined fee and terminate their lease. This practice benefits landlords and tenants alike and should be specifically allowed by statute. Security deposits help protect landlords against losses due to tenant-caused property damage and unpaid rents. Unused deposits must be returned to the tenant, and landlords are subject to stiff penalties if they wrongfully withhold a deposit. State law needs to clarify that the deposits belong to the property owners, and that the property owners can specify in a property management agreement what the management company can do with the deposits being held on behalf of the owners. Unscrupulous firms prey upon Arizona tenants with claims of helping them break a lease. These companies charge hundreds of dollars, yet landlords nearly always prevail in court. These firms harass landlords by making claims of hundreds of defects in the rental unit and then not allowing the landlord to enter to inspect or repair the supposed problem. By clarifying what constitutes a material defect and allowing the landlord to enter to fix the problem, this bill will protect innocent tenants. When a renter dies, there is often confusion about what to do with their possessions and who to allow to enter their rental unit. By allowing a tenant to designate somebody to take control of their possessions on behalf of their estate will remove this confusion and allow the owner to return the rental unit to market sooner. Justice courts provide Arizonans with a cost-effective, efficient means for addressing civil disputes. Approximately 95% of special or forcible detainer lawsuits, also known as evictions, are brought against tenants for failure to pay rent. Of those cases, 95% of them are not contested by tenants and result in a prompt default judgment for landlords. A flawed, unscientific study of evictions in Maricopa County has claimed this to be an injustice. The opposite is actually true, as tenants who dispute the facts still have their day in court, while costs are kept low for the landlord. Yet there is room for improvement, and the AMA has partnered with the manufactured housing communities of Arizona to write this bill to clarify communications and ensure due process for all.
This bill will help tenants understand their rights and the consequences of a forcible or special detainer action. It will ensure that notices are served properly and include the information tenants would need if they wish to cure the default before trial or contest the action. It will further clarify the trial process and help ensure uniform application of the law throughout Arizona.
AMA members pay attention and they understand the importance of government decisions on their lives and their businesses. As an example, AMAPAC, the AMA's Political Action Committee, is one of only 19 super PACs in the state. In 2007, we're asking the legislature and the governor to support these changes for the benefit of Arizona rental housing providers and all their residents.